Joseph Dixon, DOC number 103474, second class offender. Eligibility date 3/1/2022. Good time date 9/21/2036. Full term date 8/16/2043. A 42-year, 3-month, 26-day sentence. Secondary cruelty to juveniles, manslaughter. Does that sound correct?
Yes, it is.
All right. How old are you?
I'm going on 59 years old, sir.
How long have you been incarcerated on this 42-year sentence?
20 years, sir.
20 years on a 42-year sentence. And what do you currently do there at the facility?
Well, I am on light duty right now because of I have a operation. Something went wrong with my hip. I have deterioration in my left hip. My pelvis bone and my femur bone is deteriorated.
Okay, so you have to get it replaced.
If they can, it's not guaranteed.
Tell me, do you have a GED or high school diploma?
Yes, sir.
Which one?
I have a GED, sir.
You got it while you're incarcerated?
Yes, sir.
And did you what age did you drop out of school in?
Well, I dropped out of school. I was about.
What grade?
I wasn't in a grade, sir. I was in special ed.
Okay. And you got your GED. That's good. How'd you drop out? Just weren't doing well?
Wasn't doing well. Had family problem. Things was going on at my house that I really didn't like.
Have you ever done drugs or alcohol?
Yes, I have, sir.
Are you an alcoholic or a drug addict?
I did drugs until I come to this this term right here.
What'd you do? What kind of drugs did you do?
I smoked marijuana, drunk beer occasionally, maybe a little gin.
So tell me about your crime. I mean, it's been 20 years ago, but this is a significant, bad crime. Tell me exactly what was going on through your mind. I mean, you got the second-degree cruelty to the juveniles, and look, that was on what in 2002. You got, and then the manslaughter. Talk to me. Tell me what's going on with all that.
Well, the manslaughter came from my stepfather, who abused my whole family. He molested my whole family, and I didn't like the idea of what he done. And I could not rest. Anything I did, school or anything else that I done was not. I was not capable of functioning and focusing on my life like I should, because I knew my mother and the rest of my family was in danger of this man. And it seemed like at the time that I was the only one that really understood what my family was going through. And I often sat down and talked to him when I got older and asked him why he did the things he's done. Like one time I caught him trying to sleep with my sister in her room. And I told my mother, but the only thing happened was that he became vindictive of me and tried to hurt me in ways that really didn't make any sense. And I had to deal with this all my life. So when I got bigger, the age of 16, 17, I tried to leave. And my aunt ended up calling me. I went to job court, tried to get my life right. But she ended up calling me and I had to come back. he had beat my mother and put her in the hospital. And two of my brothers was with me. They wouldn't come. So I felt bad because that's my mother, and I wasn't gonna just leave her like that. So I come back. And when I came back, he called himself one day, tried to hit her. And, that led my other younger brothers and sisters to come get me. I was fishing. And when I came, he had a shotgun sitting down on the sofa. And he told my mother that if I did anything to him, he was going to kill me. So he knew what was in my mind, what I was thinking. And I went outside and I got a stick. And I come back in the house. He tried to pick the gun up to kill me, but he did not kill me. I got to him first. And that's the manslaughter.
Right. And
Now,
you made it out on that charge, didn't you?
yes, sir. I stayed out 10 years and a half on that charge.
Didn't you? All right. In 2002, you got a cruelty to juvenile, 2nd degree cruelty to juvenile. What's going on with that?
Well, I was in school. I was doing pretty good for a while. I got married, doing Bible study in the community, helping children out, and my life was great for a while. But then things started happening that I wasn't used to. And what I mean by that is, me and my wife, we separated because of differences. And when she left, it really hurted. I was in a bad state of condition. I went to the hospital. I almost lost my life. And I got out. I did about maybe a year and a half of therapy to try to walk again. And it just seemed like I couldn't get my life right. So I met this young lady. She was younger than me. She was, in fact, had just come back from another state, and she had 2 children. And one of the children was a little girl named Tatiana, and she was 6 months old. And when I met her, things that went on with her was not really well. I was in school, going to be a mechanic, and we hooked up. But there were some things that she didn't tell me when we met. And the thing that was she didn't tell me was that before me, that she had, in fact, the mother of her son was allowing him to watch pornography. And I didn't know that when I met her. And come from school one evening, and I was working at the school in Cottonport, Louisiana. Votech is where I went, and she told me that he was doing something that he didn't have no business, and he was trying to mess with his little sister. Like I say, he was only 7 or 8 years old. So I told her, I said,
"What did you do?" That's what I want to know. What you did? You got the charge. Tell me.
Well, the first thing I did was I took him to try to get help. I actually took him to try to get help because I didn't.
You didn't do anything. What I'm saying, what did you do for those charges? You received that charge. What did you do?
Oh, I whooped him, sir. I whooped him. She told me that I was his stepfather, and she told me that if I cared anything about him, I should discipline him. But I admit that I shouldn't have never got involved.
Did you hit him with a cane and an extension cord and a wood stick?
No, sir. whooped him with a extension cord because he wouldn't stop trying to be with his little sister.
So what have you taken, all that going on, what have you taken that you learned about yourself? What have you taken that you've learned about your anger? You've learned about the awareness of victims. You learned about, what have you learned?
I've learned that I was wrong, first of all, for not walking away from the whole scene, the whole situation, because it affected me in a negative way because of the things that I went through in my life.
So you've taken anger management. You learned from anger management.
Yes, sir.
What'd you learn in anger management?
I learned
Cajun rage.
Cajun rage and anger management. I learned that being violent is wrong. It's totally wrong, for to hurt anybody. And I realized that from taking that I didn't just hurt him, hurt myself. I hurt my family. I hurt everybody that loved me, and I'm still suffering from that, and I done got older, and I'm understanding that I even hurt society. I didn't confirm to the things that I said that I could do out there in the world.
When did you take the anger management class?
I took Cajun rage, I think it was. Cajun rage and anger management is the same thing.
Right. When?
I can't exactly call the year, but I have should have some type of verification because
Right. I'm just asking you.
I can't call the exact time, but I took it here at DCI.
Warden, you have a date on that?
I see a certificate from 2012 in his record somewhere. Anger management program in March of 2012 at DCI.
Okay. And of course, and you got a whole lot of write-ups since 2012. Now, of course, I see you got one dismissed of fighting in 2020. They dismissed it. I understand that. It concerns me that you had a defiance, in 19 and an aggravated work offense. What was your aggravated work offense at the time?
Oh, I was told to get up out the bed. I was hurting. Like I said, I had said that I was getting up. I was tired, and I didn't get up in time enough that the guard was really satisfied. So I got a write-up. I'm responsible for getting it.
All right, that's it. Warden, you got any input for me?
Joseph's been here since 2017. He has had quite a few write-ups. On a positive note, he has completed automotive technology, collision repair technology, and he did serve as a tutor for a while. He's currently a CLN or on light duty, and he's followed by ortho right now. That's all I have.
All right, thank you. All right, would you like to make a statement on your behalf, Joseph?
Yes, sir.
Go ahead.
I understand that things happen, and I know for a fact that I was wrong for what I've done, and I've come to in my mind to understand that I was wrong, and I would never try to uphold the fact because of what happened. I'm responsible what happened, but like I said, it would never happen again. I would never put myself in a situation where, I'm putting my life ahead. In the back, and putting someone else's life in the front of myself. Because each time I come in here, I don't come in here for myself. I come in my here for trying to help somebody else. And even though it's for good reason, I'm losing my life, you know, and I'm calling myself trying to do something right, but it ended up being bad, you know. So, you know, I'm not gonna put my life on hold like that for anyone, no more.
All right. Okay. Sounds good. Pam, prepared to vote. I'll vote first. Listen, you know, you're right. You need to think about you. That's exactly what you need to think about. You need to, you know, take ownership and responsibility for everything you've done. You had a great opportunity. You committed manslaughter. You got out, and then you know, you should have been walking the straight and narrow, but you didn't. Look, it's never appropriate to beat a kid with an extension cord. I mean, look, it's never appropriate to hit children, young children. But you know, you had opportunities. You had multiple opportunities. You still kind of, you know, I think you need some victim awareness. Take thinking for a change. Take something to kind of get a grip with what you did and what you've caused. You're right. It's real. You know, other people didn't get you in there. You got you in there. It ain't no other people got you in there. You got you in. You're in there because of what you've done, not because of what other people have done. And that's something you got to come to terms with. I'm not prepared to vote to grant you today. You have poor supervision. You need more programming. Your institutional record. So my vote is to deny today. Mr. Marabello.
Thank you, Mr. Chairman. Mr. Dixon, it looks like you need a little more work. You're moving in the right direction. I agree with Mr. Kelsey. My vote today is going to be to deny as well.
Ms. Renata.
Mr. Dixon, I was concerned about what you said, that your actions were for good reason. In either case, particularly in the case of the child, I just can't agree with you at all. So I believe you need some awareness training and you need to reckon with what you did. My vote today also is to deny.
All right, you have 3 votes to deny your parole today. Your parole's been denied. Good luck to you.
Well, let's unpack this with some reality, I guess, and some truthism to this hearing. I was listening to it and just kind of confused. First, we hear about the manslaughter where he served just 10 years, but what it seems to say was more like, why are you serving years at all? You should, you know, you seem like a hero. And maybe he was, what his stepfather was doing and what he did. But, and then you have this case where it sounds like, well, he kind of tries to give a strong reason as to why he would do this to to the boy and to the little boy. And he paints this picture where it's not so, but we'll go into the details. And it was, of course, much, much, much worse than he tried to let it on. Still, it does amaze me that he received a 30-year sentence for what he did to this boy when people receive 5-6-year sentences for doing horrible deeds to children. So it's, you know, the law is all over the place. And it could be that some judge didn't like that he only served 10 years for his previous sentence, but let's go through it. It's pretty gnarly. So the defendant appealed his second degree to cruelty to juvenile and his sentence of 30 years at hard labor. He asserts that the sentence imposed was excessive in comparison to the 9 years that his co-defendant, the mother, received. So she got 9 years. You know this was bad, right? Additionally, he maintains the trial court erred in determining the competency of the child witness and the sufficiency of the evidence. So, at trial, the victim testified that the victim, who was 7 years old and lived in South Carolina with his mom and dad, the victim testified that he used to live in Marksville. When asked if Joseph Michael was in the courtroom, he pointed out to the defendant. According to the victim, he lived in the same house with the defendant between January and March. So not that long, just a few months. While living in the same house, the defendant whipped the victim with an extension cord on the victim's buttocks, legs, back, and neck. The defendant made the victim take off his pants and whipped the victim underneath his clothing. When asked how many times this occurred, the victim replied, twice. According to the victim, he bled when he was hit with the extension cord. The victim further testified that the defendant hit him in the ankle with a walking cane. When asked if the defendant ever hit him with his fist or hand, the victim stated that the defendant hit him with a fist in his stomach and back. When the defendant hit him in the stomach, the victim's breath was knocked out of him. The defendant also held the victim up by his ankles and dropped him to the floor, causing the victim's stomach and lip to hit the floor. When asked if he bled or got a busted lip, the victim replied, "Yes, ma'am." It's a little boy. The state asked the victim if he started to bleed or anything when he was hit with the walking cane or extension cord. The victim replied, "No, ma'am." The extension cord. When the state asked the victim to tell about the extension cord, the victim replied, "When he had hit me, it started bleeding." According to the victim, the bleeding occurred only once, and the pictures were taken of his wounds. The victim identified S3 as a picture of his legs. The picture showed the victim's legs with red marks, bruising, and open wounds. We note that one of the wounds in the photograph looked as though it was bleeding. When asked how it felt, the victim replied, "Bad." The victim also stated that the injuries lasted more than 1 month and were present after he moved to South Carolina. It's just... yeah. Next, the victim identified a photograph which showed bruising and what appeared to be, although it's hard to tell, wounds of abrasions to his buttocks. And, again, it's interesting that they put a 7-year-old on the stand for this, but they don't do it for all of the cases that we see when it's sexual abuse, and they just don't. And it's like, it really, in my opinion, the court, either they want to go after someone to lock them away and then they just don't care, or they just view it very differently. Getting beaten versus getting, State Exhibit 5 was identified by the victim as picture of his knees, which appears to be bruised and swollen. When the state asked the victim what happened to his knees, the victim answered, "He hit me with this cane on my knee." And this is all being done and complicit with his mother. So, this poor kid. And it goes on. They ask all the questions. They go through the pictures. On cross, the victim remembered talking to Detective Hubert. When asked if he remembered telling the detective that someone else besides Michael hit him with the extension cord, the victim replied yes, and named his mama. According to the victim, his mother hit him one time, but at a different time than Michael Dixon hit him. Now he has to live with putting his mother in prison. The victim also stated that his mother made him take his clothes off. When asked if he remembered talking with the detective about his aunt in some movies, the victim replied that he did. However, he did not remember whether or not being hit with the extension cord had anything to do with his aunt or the movies. Defense counsel asked the victim if being hit with the extension cord had anything to do with someone showing him something nasty, and the victim replied, "No, sir." Although at trial, the victim denied having a cousin that did something to him, he remembered previously saying that he did. It's just a broken home. It's just a travesty, the whole thing. Sean Davis, child protection investigator, testified that the victim was 7 years old, while the defendant's age was 38. She also testified that the defendant was the victim's stepfather. Ms. Davis saw the victim's injuries on March 1st and identified the photographs introduced as fair representation of the victim's injuries at the time. According to Ms. Davis, the emergency room hospital reported this incident. On cross-defense, counsel asked Ms. Davis if she questioned the defendant as to why he whipped the victim. Ms. Davis, which is her mother, right? oh no, that's the child protective investigator, stated that she asked the defendant, and he stated that the child was bad. He just was bad, a bad child. And that this was his method for disciplining him. It's just, in further questioning the child, which was in part examination, and the conclusion drawn, he states that not only had he been whipped, he had been dropped, thrown on his face several times, and cross-questioning. Remember, this is only 3 months of living with him, so it is quite amazing that they caught it so early, you might say. This could have gone on for years. It could have gotten worse and worse until even something worse could have happened. So we're lucky that he got caught after 3 months. And cross-questioning, re-questioning, he was very consistent with the stories, stating to be a well-developed young male, weighed 74 pounds. He had a hematoma or a swelling on his forehead that measured 1 inch by 1 inch. He also had a laceration or a cut on the upper lip. Both of his upper and lower lips were markedly swollen. He stated that it occurred on Thursday. Yeah, the kid was more than just whipped. Obviously, you could see he was beaten relentlessly. And they go on to much more detail. There's a lot of questioning. The article goes on and on and on, but I it still is. It's surprising to me that he got 30 years for this, but they gave him the maximum, and that's probably. Let's see if they go through here. Prior to sentencing, the state withdrew the motion to have the defendant sentenced as an habitual offender. The trial court noted that in preparing for sentencing, it had reviewed the entire record of the proceeding, the pre-sentencing investigation report, correspondence sent by the mother of the victim, as well as applicable law. The pre-sentence confirms that the defendant had previously arrested for second degree and pled guilty to manslaughter. The defendant was also arrested on 2 counts. Okay, so he has more violence of aggravated assault, but found not guilty. Subsequently, the defendant was charged with aggravated battery and pled guilty to simple battery. This guy, he's very violent. Who knows the story with him and his stepfather, right? According to the PSI, the defendant in his second felony, as noted earlier, the state withdrew its motion to have the defendant sentenced as an habitual offender. But they gave him the maximum. It's I wish that they would take these type of sentencing approach when people are doing this, abusing children in a sexual nature, but they don't. And I think that's crazy because there's no rational reason why they shouldn't, but the law is all kinds of messed up, and he shouldn't be released until he holds himself accountable and until he can be honest with what he did and why he's doing it. And obviously he's got a lot of problems he has to work out. I'll put the link in the description. Thank you, Richard, for sharing it. With that, I'll let you go.